made the threshold for grant of interim conservatory orders against the respondents, their agents, servants, employees in processing, preferring any criminal charge against the petitioner pending inter partes hearing of this matter, which I've said, you know, we are dealing with a patient in ICU, it must be an ICU, which I've said at a very high priority that inter partes must be had on 12th of this week, on 12th, in view of this particular application, 12th of September 2019. That in terms of Article 49, which entitles the rights of an arrested person, very with the spirit, Article 49. And I bear in mind, as I make this decision, I have not given a chance to the PP to say we are comparing this on judge for us to be able to not to exercise the powers granted under Article 49 to allow the petitioner be on bond as provided for under Article 49. But that as it may be, the applicant, if the respondents and their agents have not exercised this right, I'm going to move this court under the Constitution, Article 49, and grant that this petitioner be released wherever he is within the borders of this republic, be released on bond of 100,000 with assurance of identical amount. And I've also issued on an alternative, the petitioner can deposit a cash bail pending the outcome of this petition of 20,000.
Two things. The manner in which exhibits are handled is purely a function of the judicial officer. There is elaborate law on how that is supposed to be done. In this particular case, a request was made by the prosecution that they be given those exhibits. The magistrate, upon hearing that request, exercised his discretion, considered the facts and the law, and came to the conclusion that once exhibits have been produced in court, they cannot be released to the police. He therefore ordered that they be kept under custody by the court officials. So the exhibits left his courtroom, and they have never been under his control. Now, if there was any grievance on the part of the prosecution so far as the decision of the magistrate is concerned, then a revision or an appeal ought to have been mounted. We are saying that the DPP cannot seek to countermand a decision of a magistrate through a process other than a revision or an appeal. Insofar as the decision of the magistrate has not been appealed from, has not been challenged on account of a revision, then there can never be justification as to why these criminal proceedings have been brought against the magistrate. It is collateral. And so far, from the statement of the Director of Public Prosecution, it's quite evident that it's somebody else who took custody of those exhibits. It's not the magistrate. So the magistrate cannot be brought into the trial when in actual fact his functions were limited to what is given to him by the Constitution and the statute to try and determine cases.